Good afternoon and welcome to another edition of Florida Appeals Journal. I'm Jennifer Carroll, and today we're going to talk about another mysterious issue that faces everyday practitioners in the world of civil litigation. That issue concerns charging liens. That's today's topic, charging liens. What are they? How do you enforce them? And so we'll also give some good practice tips. So this is for attorneys really in any type of civil practice who can time to time be concerned about collecting on fees that are owed to them for the hard work they've done in litigation. All right, so let's talk about a charging lien. First of all, charging lien is different from a judgment lien. It's different from a retaining lien. You often think of a judgment lien. You sue someone, you get a judgment, and then you go and you collect on that judgment. So that would be a judgment lien. And a judgment lien, you can go against properties, monies that are outside the litigation. Retaining liens, that's another type of lien. And I'm telling you these others, so you'll see how a charging lien is pretty unique. That's a lien for payment of an attorney's services that's against client property that's in the attorney's possession, and regardless of whether the property is related to the matter for which the money is owed to the attorney. So the attorney has a retaining lien. Now, be careful, because if that property is earmarked for a special purpose, then you can't touch it. Okay. But now a charging lien. A charging lien is a very interesting lien. That goes against the, quote, fruits of the litigation that's at issue. By definition, it does not apply to outside property, and that's property outside the subject matter of the litigation in which you rendered your services. And it's not going to apply in cases where there are no fruits to the litigation. So in other words, you have to do something positive for the client, right? Whether it's a settlement, positive settlement, or positive outcome in the case after a trial, and you've gotten a positive order for the client. And that's very important. So you have to have that. All right. And something to keep in mind, in some limited instances, charging liens can even attach to alimony payments, never to child support. But there are cases that can help you if you ever have that kind of issue. All right. So if let me point out that the law prefers with these charging liens that you basically litigate that in the litigation that's at issue. And that kind of preserves the, I guess, sanctity, confidentiality of the attorney-client relationship. And so that's preferable to you going and having to sue the client outside that litigation. So when possible, it's always good to have a charging lien. You want to put that in your representation agreement, the right to seek a charging lien, and you got to follow the procedures for it. Okay. Now, to have a valid charging lien, let's just talk about some of the basics. There has to be an agreement, express or implied. Usually you want to put in the rep agreement, like I said, that your fee is recoverable from the proceeds of litigation. So normally you include a provision in your rep agreement, and the clients usually have no issue with that. There has to come a time where the client is disputing the amount due or just refuses to pay the amount. And unfortunately, this does happen in attorneys' practices every day. So this is a way you protect yourself, but that's the second element. And the attorney has to give the client adequate notice of the intent to seek a charging lien from the proceeds from the recovery in the case. So you want those, that's the checklist. That's what you have to abide by. To perfect the charging lien, if you satisfy those elements, the only requirement for perfecting it is the notice, timely notice to the client and the other parties. All right. This is very important. The notice, and when you're dealing with charging liens, procedure is extremely important. So you have to dot all your I's and cross all your T's, right? Okay. So the notice, or you can call it a motion, some people say call it a motion, but the notice of charging lien, you have to file it before your original action reaches its conclusion, right? So before the case goes to a final judgment or it's dismissed. Um, and again, the legal services sought to be charged has to produce a positive result, a positive judgment or positive settlement for the client. For the client, since the lien only attaches to the tangible fruits of the attorney's services. Um, and the amount of the charging lien will be decided in that litigation, and it can be summarily enforced by the court in the same proceeding. So it's a lot easier, really, for the attorney, for the client, to keep it in the proceeding and to get it done. And no, you don't really need an expert witness for the reasonableness of the fees in charging lien situations. And this is an important point, those fees are contractual fees, right? A charging lien is contractual in nature, and it's to be based upon the amount agreed to with the client, not an amount that's determined by the trial court. A very important fact you want to keep in mind. Now, you do want to remember, of course, if there's a challenge that, well, it's an excessive fee under the Florida bar rules. I think it's 4-1.5B. Um, I think that's the rule that talks about you can't have an excessive fee. Then it can be challenged, but you can't challenge it on, well, on just plain reasonableness. So that's the only caveat uh, for the challenge. All right. The practice tip, always include that provision in a written fee agreement, and you want to specifically provide for a charging lien in the event of non-payment. And what's also very important with a charging lien is it's not only enforceable against your client, it can also, and nobody likes to even get in these situations, but these situations do arise. But you may need to go against the opposing counsel, the opposing party, because you may have a situation where the case was settled behind your back. There could have been some fraud involved. And there's case law out there that if that has occurred and you've given your notice to everybody of the charging lien, you can go against the opposing party for your fees. So if the opposing party or opposing counsel even who has notice of your charging lien sends your client a settlement check and the client fails to pay you, your lien can be enforceable against the opposing party as well as your client. So that's an example of a situation where that will occur. But always remember, time is of the essence with these charging lien situations. Once the court has lost jurisdiction over the parties or the subject matter of the case, either because the case has concluded or the property's been disposed of or removed beyond the jurisdiction of the court, your lien, if not previously noticed, will be unenforceable. You don't want to get yourself in that situation. Okay. And another tip to remember with respect to charging liens, there are special rules that apply to charging liens with contingent fee contracts. That's a little different. I believe the case is the Cersei Denny case, 652 Southern 2nd, 366. And they talked about, what method, you don't really use the lodestar method of computing reasonable fees as under Roe. Don't apply it in that context. They usually will do the quantum merit principles in evaluating the type of fee in a contingency case. And they use the factors, and actually it's the 4-1.5B factors. And I cited that earlier, but really that pertains to the factors that the court will look at with respect to assessing fees in the contingent situation. Any other tips that you need to be aware of? Let's see, the Gossett case, 941 Southern, Second 1207. That's 4th DCA. No expert testimony is required to prove the amount of a charge lien. And again, that's because it's really the fee that was agreed to with the client. That's contractual. So you don't need an expert to come and say, hey, that's reasonable. And the case Franklin and Marvin, PA, 711 Southern, Second 46. And that talks about also, well, in the absence of a legal determination by the court that the fee contract is illegal, prohibited, or excessive under a periodic fee agreement for services already performed, the lawyer is entitled to a money judgment for the amount of fees due under the contract. But again, that would be, I think that case is more towards if you want the money judgment, but you really want a charging lien, which can be enforced in the underlying case that you were involved in. Also, in dissolution of marriage cases, a charging lien can attach, this is interesting, can attach to equitable distribution. But as I said earlier, not to, well, in some instances, alimony, but not to child support, certainly, but to the equitable distribution. And that's the Littman case, 517 Southern 2nd 88. So those are some key principles that govern charging lien, what it is, how to enforce it, and some practice tips. Again, just be very precise on the procedure, and I think you'll find that you've got some good protection there and a more streamlined way to collect a fee that isn't paid. As usual, any questions, please let us know. Thank you and good luck. Hi, I'm Jennifer Carroll, and I want to thank you for watching our video. You can see more of our videos right here. Or better yet, subscribe to our YouTube channel below so you won't miss a single one.